Welcome back to the Fostering Financial Victories podcast. This is season 2, episode 2. So I have got a special surprise for today. So this is a topic that we have not talked about before. It's something that a lot of folks have asked us to go into detail and cover. So we're going to talk about estate planning a little bit. So I am joined by Austin Taylor. So Austin joined our team a few weeks ago.
Yeah, January.
And this is all still a little bit new, adjusting to a new normal. Yeah. So Austin, kind of tell us how you got to where we are right now.
Okay. Well, I have been in practice as an attorney for about 12 years. And so working with clients one-on-one and doing a variety of things. I actually started in family law. I've done a lot of real estate law and some estate planning. And so I was approached by Paul and by Foster Victor a while back, and we started conversations about what it might look like to have an in-house attorney or general counsel for Foster Victor. And so I have accepted that and come in January, and here we are.
Yeah, a little different scenario,
a little bit different,
right?
Very different from what I was doing.
So are you charging us by the hour for this?
Yes.
Okay.
Yeah, so we should probably
Or by the minute?
Mm-hmm.
Okay, so we should probably get going. Mm-hmm. All right. So estate planning, pretty big topic.
Right.
One of those really important topics that people oftentimes will have a lot of questions about, or it may be one that they've avoided talking about completely.
Right.
What does that actually mean? What's encompassed when you talk about estate planning?
So for most people, we don't think about estate planning on a daily basis. You shouldn't think about your own mortality on a daily basis. That'd be no fun.
It'd be a little weird.
But you need to at some point. And it basically involves, for most people, setting up a will, maybe a durable or financial power of attorney. Some people have a healthcare power of attorney, which you should, and possibly a living will or directives for what happens if death is imminent, what you want to happen.
Okay.
And so for most people, it's a pretty simple process and one that everyone should take part in.
So is there a time of life or is there an event that might trigger someone to say, hey, I need to go do this now?
Well, so I would say everyone needs it. And the reason I say that is because if you own any assets at all, if you own a home, so maybe that's a triggering point. If you have children that you want to leave assets to when you pass away, that may be another one. But really, I start with if you own anything at all, because estate planning helps you decide what's going to happen with your assets when you pass away. If you have a retirement account, if you have a job, you need estate planning. Okay? And you start that process by speaking with an attorney about what it is you have and what it is you want to protect.
Okay. So someone should start it early on. Mm-hmm. Like it's not, hey, you got to be 50 years old to start worrying about it. How do they do it? Okay. So there's a lot of ways that I've seen people try to approach this.
Right. Well, LegalZoom is not the way to do it. Okay, I'm going to go ahead and say that.
Okay.
And the reason I say that is because there is no one-size-fits-all estate plan. So first off, I want to dispel the notion that you have to be very, very wealthy to need estate planning or that it's going to be insanely expensive to go through that process, because that's not the case. It's usually right in line with what you're trying to protect. So a very simple estate plan is going to be much less expensive than a very complicated estate plan where you have lots of assets and maybe lots of heirs, lots of charities that you want to divvy things out to.
So the cost is always something that people ask about. And when they ask myself about it from an advisor's perspective, it's kind of hard to give them an exact expectation because attorneys are all over the board with what they value their services at, obviously.
That's true. That's true. And so part of my role, this is kind of jumping into something different, but part of my role at Foster Victor is going to be to sit in with our clients and get an idea of what their assets are, what their needs are, and try to help maybe pair them with outside counsel who is offering a service that is in line with what they won't need to spend and the type of documents that they're needing to create.
Okay.
So you're right. It's all over the board, but a very simple estate plan, maybe $750. A very complicated estate plan could get into the tens of thousands. So something we can help do is pair our clients with the right, or recommend the right outside attorneys that are maybe offering services in line with what they need.
So you mentioned a few minutes ago about some of the elements involved, power of attorneys and those things. Who are all of the people that you need to have an idea of who you want to assign maybe a task to as you start going into this conversation? So if you have kids, I assume that you would need some guardianship done and trustees and all that. So can you talk through a little bit of who are the players?
Yeah, who are the players? So when you're going through an estate plan, let's start with the will. And I'm just going to talk in terms of what we call a simple will, okay? And a simple will might say all of my assets pass in this certain way. And so you need a couple of people involved to make that happen. You need to name a personal representative. A lot of people in a lot of different states call that the executor, okay? But you're going to name someone. It's important that you name at least one successor to that person, because if that person were to predecease you or was unable to serve as personal representative, then you need an alternate. Okay. If you have young children, then guardianship is important. Who would take care of those children? Secondarily, usually a simple will set up a type of trust for children if they're minors at the time that you passed away, and who's going to be the trustee for that trust. A lot of times that's the same person as the guardian. But that's what you're looking to do. Under your durable power of attorney, which is kind of your financial power of attorney, then you are saying what person, if I'm not deceased, but I've had a terrible car accident and I'm unable to take care of myself, what person am I allowing to step into my shoes and take care of all of my financial needs? I also think it's important to name an alternate for that as well, And then health care power of attorney. If I am in that car wreck, I hate to keep putting myself in a car wreck, but if I'm in that car wreck and I'm at the hospital in need of some type of surgery and I'm not conscious to make a decision about it, what person can come in and give doctors permission to maybe take certain medical steps on my behalf? And also an alternate to that. So those are the players.
Do you see where... for the power of attorney piece, is it common to have different people as a financial representative or a healthcare representative? And does that muddy the water at all? Or what are your thoughts there?
No. So I would say the most common thing that we see, or that I did as outside counsel, was maybe your children, if you have grown children, serving as that durable power of attorney or that healthcare power of attorney. It can also be a trusted friend, and those people don't have to be the same. Healthcare is going to be specific to what can a doctor do, what permissions can they give, and that's going to be the person they're calling from the hospital with a need. That doesn't necessarily need to be the same person who can go withdraw money from a bank account or help pay a nursing home for your care.
Do you ever see it where, so let's say you have multiple children where they don't want to play favorites for whatever reason, and they list both of their kids as the power of attorney?
Yes, you can have co-agents, It's usually, you're usually going to give them power to act together or separately. But some people do limit it to they always have to sign off on the same thing. It could potentially complicate things if you can't get those two people in the same place to make an action. But you do have parents who feel like, I want my children working together. I want them to be co-representatives or co-agents. Most lawyers, I think, though, would encourage there to be some ability for each of those to act on their own as well, just for purposes of decision-making and timing.
Yeah, it definitely seems like that would delay it.
It could.
Yeah.
It could.
I know with my kids, they all have different personalities, and I don't think they could ever agree on what might be the right way to go.
Right.
Okay, so misconceptions about estate planning. You just hit on one of those. You don't have to be uber wealthy to need one of these. Are there any other roadblocks that people might have that they've artificially put in front of them to say, I don't really need to do that?
One that I used to hear a lot was that I don't need to do that because the law in South Carolina sets up a process for probating. It's not going to be a process that is easy and seamless if you have not given it direction, So if you don't leave a will, then when you die, if you have assets, someone in your family usually is going to have to start a process with the probate court. If you die and you own a home, for example, there's no one left to then sell that home and convey title to the next person if the court doesn't come in and name someone as personal representative for your estate. So we call that dying intestate, meaning without a will. And there is a process under the law so that, assets don't end up going nowhere. But it's not an easy process, and they may not end up in the place that you wanted them to. It may make it very hard for your family.
So with dying without a will or intestate, as you just termed it, if that happens, and let's say you have a family that has minor children, how does the court decide who is the executor? Do your next of kin just come in and basically stake claim to, hey, let me be it? Or, how's that work?
So there's a process for filing an intestate estate, and whoever is taking the lead on that, whatever family member has taken the lead on that initial filing, oftentimes asks that the court appoint them personal representative, but then the court would hear other family members if they contest that. Same with guardianship for children. That's very tough if you've died intestate, especially if there's not a surviving parent. So both parents are killed in a car crash and there's no will. They're going to certainly look to the next family members. But, do grandparents come forward? Do aunts and uncles come forward? Probably. And then the court's got to make a decision. So that is a process where they're going to interview people and try to make a determination that they think is in the best interest of the children. That's complicated. Okay? That's not what you intended to happen if you're the mom and the dad.
Sure.
So that's why you make some of those decisions. If all you have is children and you don't own your home, it's still important that you have an estate plan to direct what happens if you're not here.
Got it. So with the state law perspective, kind of get into that probate situation. What's the timeline? How long does that usually take?
So if you have a will, if you are probating a will, then it's going to last at least 9 months. We'll say that in that process, because there is a 9-month period where creditors could come forward and say, I was owed certain money and I need to be paid out of the estate. So it's usually around a 9-month process. It can take longer if there are more assets to be, to deal with. If there are a lot of moving parts, then it could take longer than that. One thing I would say is that one of the goals of estate planning is to avoid as many assets as possible from ending up in that probate process. And you can do that several ways. You can use trust to do that. You can use titling of your assets and business entities to do that. It all sounds more complicated than it is, but the goal through your estate planning documents is to not have assets end up going through that probate process, or very few, so that it's simple.
Okay. So let's put a real scenario in place. So husband and wife, one of them dies, they have young kids, no estate plan, start going down the probate scenario. Are there assets that cannot be accessed until that's finished for the surviving spouse? If so, how does that play?
There could be. I mean, it gets complicated because you would have to know what that couple owns, how things are titled, that type of thing. But could it be hard? Yes. The children aren't going to be an issue if those parents were together and there's no court order in place that has anything to do with custody of children. Okay. So let's say mother has passed away. Dad's still going to be there for the kids. So you don't have those guardianship issues usually. But you may have issues of things like bank accounts in her name alone, or maybe retirement accounts in her name alone. If beneficiaries weren't set correctly, then he may have a hard time accessing some of those funds, even life insurance policies. It's getting a little off topic, but part of what you want to do in an estate plan is also check all of your assets to make sure that your beneficiary designations in things like a life insurance policy or 401k benefits, that they are titled properly so that if something happens to you, it's obvious who those things are supposed to go to. And so he may have to have the blessing of the probate court before he can access any of that. And he will have a process where he has to keep that probate open for creditors. But hopefully she's done a little estate planning and he's not having a problem with titling of the house or anything like that.
Okay. So if he has young kids, and there's no will, there's no anything in place, how are assets that are not beneficiary titled?
Mm-hmm.
How are those distributed?
Okay. Well, one of the main things that we look to is titling of real property. So I spent a lot of time handling closings and working with people on real estate.
Okay.
And in South Carolina, there are two basic ways that people own real estate with their spouse. That's usually as what we call either tenants in common, which means we each own 50-50, and potentially 50% of that ownership could pass through our own probate estates, or we own it as joint tenants with rights of survivorship, and then the surviving spouse automatically has 100% ownership of the home when the other spouse dies. That's preferable, in my opinion, for estate planning. And hopefully, this poor lady that we've killed off 5 minutes ago, hopefully she and her husband hold title that way. And if he's in a financial crunch after her death, then he then has the authority to sell that house. If it's titled the other way, and it's stuck in probate to a certain extent, he's going to have approval of the court to deal with her half of the ownership.
Because technically the kids would have inherited it.
Well, there's this other process where her heirs, we have a process where it goes, her stirpies to our heirs is the default in South Carolina.
Okay.
And that just means it goes to, we have a spousal elective share potentially, and then we also have this per stirpies to heirs. So there is some inheritance investing immediately in the children at her death as well.
So that makes it really, really complicated.
It could complicate things if he needs to sell that home during that time. So we also encourage taking a look at how your property is titled and making sure that that's the best way if something were to happen to you.
Okay, so you kind of took us down the road of South Carolina law. Mm-hmm. So I know a lot of people that listen to this aren't in South Carolina, which that's okay.
Right.
Common law marriage.
Mm-hmm.
Is that a real thing or is it just a myth?
So it does exist. And in some states, you still have a real issue with people coming forward at the death of one person and saying we were common law married and having to show proof through the court that existed. And there are elements to proving that, okay? I'm not going to pretend to know the laws in every state. Yep. Here in South Carolina, it's very difficult to prove now, okay? And it does not come up as often. I don't know in Georgia and North Carolina if there's still issues with that, but it's certainly, if you have been living with someone for, maybe 10, 15 years, if y'all held yourselves out to be a married couple to people in the world, if you had joint assets, things like that. I encourage the people who are relying on getting that designation that they need to do something different, that they need to do something in their estate planning to make it very specific, that they want something to go to the person they're not married to but have this relationship with. And I also encourage the people who are fearful that maybe they have been in a relationship that they did not intend to go down that road, and they're fearful that somehow they'll be proven under the law to be common law married. Don't fear that so much. Make your planning. Get with a lawyer. Be responsible about your planning, but that's not as big a fear here to me.
How often, so let's go to the other end of the spectrum, how often should a family or a person review and update their documents?
That's a great question, because part of what I'm doing, folks, let me just give you that example. When people come in to meet with us at Foster Victor and we set up an estate planning review, oftentimes they have gone through this process. They've sat down with outside counsel and they have the documents that they need. And in their mind, it is settled and done, and I don't need to worry about that anymore. And sometimes that's right. But I try to say, okay, well, here's exactly what you have. Here's what these documents say. Here are the people who are going to inherit under this. Here's how you have given to this charity, this, that, the other. Sometimes they drafted those documents 10 years ago, and they're amazed at what they say. Wait, that person doesn't even work for me anymore, and that's a non-family member. And we find things like that. Okay. So in my opinion, you ought to review it at least once a year.
Really?
Well, it's not going to change every year, but your life changes substantially with children, with job moves, with investments. All of those things change maybe what you would do and the amount of assets you have in total. Maybe when you started this process, you didn't need to worry about protecting your assets from estate taxes because you thought, right now, you would have protection for $11,580,000. You thought, well, I'm never going to have that many assets. Well, 10 years down the road, suddenly you're in a position where if you died, there could be some estate tax owed. So maybe your very simple plan needs some adjustment to protect against that.
So you brought up the estate, basically the exemption.
Mm-hmm.
Okay, so there's been a lot of talk from the political landscape, and not to go down the political road, but
that may change.
Yeah. So how often have you seen it change? I know I've seen it a couple times,
certainly.
But what are your thoughts there on anything coming down the road? Do you think that's an item that's on the table?
I think so. And, again, not to at all get political, but if you sort of follow the news and follow some of the trends, there is a chance that maybe as early as next year, the exemption could be lowered. Some people say to maybe $5.5 million. Some people have even said $3.5 million. We don't know. I have no idea.
So
but
what would that mean to somebody, like in real dollars?
Okay.
If they are not under that, if they're not over the limit now,
right?
If they passed away,
right.
But all of a sudden they move the goalpost back a little bit. What does that actually mean?
It means that when your children go to inherit, there could be substantial amounts of money owed in taxes, and that could really eat away at your estate. So the person who has maybe $3.5 million worth of assets right now is not terribly concerned with estate taxes. But if that bar were to be lowered from 11.5 to 3.5, then you're starting to have to think about that. In my mind, what it means is a conversation with your lawyer, with your outside counsel, that is, are we doing the right things through my estate plan to protect against my children or my estate being eaten up by taxes so that my children don't inherit as much as they should or as much as I want them to. And there are ways through trust, through life insurance and life insurance trust. I don't want to get too far in the weeds, but there are ways to significantly reduce your taxable estate. And so those are conversations you need to have with your lawyer. Now, I am not one who thinks it's all doom and gloom. You asked how many times I've seen that. That exemption changes a good bit with administrations. Right now, it's on the higher end. We've seen it, I think in 2009, it was $3.5 million. So we've seen it go up and down. And that's not something you need to worry about terribly over your lifetime, I don't think. But you do need to keep tabs on it and make sure that your estate plan is sort of built to withstand whatever that limit is and protect against, the estate tax potentially eating up your estate.
Okay. Is there anything else that you think potentially is on the table from an estate planning change that might be warranted to discuss?
There are always, if you sort of, obviously I talk South Carolina a lot because I follow what we call the advance sheets here and Supreme Court rulings here. On a federal level, there's the same type things. There's nothing out there right now that I think is going to, at least that I know of, that's going to make an immediate change to how I would approach estate planning as a private person or really as an outside lawyer. It's really always been about accomplishing a couple of goals for people. Accomplishing maybe probate avoidance. You want as few of your assets as possible to go through the probate process. Privacy. Sometimes we use what's called a revocable trust or other types of trust to store our assets during our lifetime so that when we die and that probate process starts, there's not this list of all of our assets and everything that we own. So privacy is important to people. And then there's that then there's that taxation avoidance, estate tax avoidance piece, if your assets are substantial, that your lawyer needs to work around. There are also issues that come up with people of asset protection, and there's ways to better protect from creditors. Or maybe if your child could potentially have judgment creditors out there and you want to protect against what they inherit being subject to those creditors. That's a difficult one in South Carolina, but it's one that can be accomplished or at least better protected against if you're talking to a lawyer.
Okay. What happens if you've done your estate planning like a responsible person and you have misplaced your documents?
Right. Okay. So in our state and in most states, I would say, there are some states where you actually record those documents. Here you do not, and in the surrounding states around us, you do not record most of those documents. The durable power of attorney will be on record with the county. That's one, as long as you record it, and that's one that maybe you can breathe a sigh of relief on. But your will, the original, has to be probated in the county where you die, and also an ancillary estate anywhere where you own real property, okay? So it's really important that you have the original of that will. And so when you have this estate planning done, put it in a safe deposit box. Tell the personal representative that you've named, hey, don't have to tell them all the details of what's in there, but I've named you personal representative. It's going to be in this safe deposit box. It's going to be, at this post office. The key is wherever it is, and give them some direction.
Okay.
Because copies you're going to end up in a position potentially where you have only a copy of a will and that's not probatable. And you're going to end up in that intestate process.
So even if you've done the documentation and you don't have the original, it could still get thrown into basically you dying without. It could still
now, if you've got something's always better than nothing, in my opinion. Okay, so if you've got something, then does that help the probate judge in guidance of what your intent might have been? It does, and they may somewhat consider that, but you can't bank on it, and they are essentially in an intestate process at that point. So not to scare everyone,
so what you're saying
store your
is
documents well.
Don't lose them.
Don't lose them.
Don't put them in that drawer in the kitchen.
Right, and don't do that, especially not at my house. But if you realize, everything can be fixed during your lifetime, okay? So if you realize you've moved and I have no idea where those documents are, look for them. And if you can't find them, that is worth a call to your attorney, to the attorney who drafted them, to say, hey, can I come by and execute new copies? They can print them out and you can execute them as of that day if you don't need to make changes. Something to be aware of.
They're probably glad to do that for you, right?
Yeah. Right. Yeah. And that may make you go and read them and you realize you need to change something.
Moving state to state, should that be another triggering event?
It probably.
Yeah.
Now, most of our states are going to have what we call reciprocity. So if your will and, maybe a trust were properly executed in the state where you had them done, most of our states are going to recognize them, okay? But every state's probate process is going to be different. So the one thing I would say about a move is that is a time to review your estate planning documents. It's a time to make a contact in the new state with an attorney to ask if there would be any problems with probating your current will.
Yep.
Or do you need to update? Is there something you need to do? Do you need to do an addendum to it or a codicil that makes clear that this is still what you want and that it's properly executed in and recognized in the state where you now live?
Okay. All right. We've covered a ton in about 25 minutes.
Right.
Told you it would go fast. Is there anything else that you think people need to know just on the high level before we kind of wrap this up?
On the high level, you just need to know that estate planning is often an uncomfortable topic, but it is a conversation worth having with an attorney. I don't want people to fear the cost. I'm no longer practicing outside. I'm not going to be the one drafting any of these documents, but if folks have questions and want to call and say, hey, who do I need to talk to, then call us. Let's try to get people with attorneys that make sense for them. But I don't want people to fear the process because it has a tendency to be something that you delay And we all know that things really happen. Car wrecks really happen. Strokes really happen. And you don't want to be in a position where you have none of that in place. So will is super important. I also think that durable power of attorney, or what some people call financial powers, I think that is really important because that is a pre-death thing. That is a I am not deceased, but I'm incapacitated thing. Mm-hmm. It's one of the things that in private practice I saw people not plan for with maybe their aging parents, and then suddenly we're dealing with issues of Alzheimer's or dementia, and they don't have any of that in place, and now they have to go through a court process to be named guardian for that person.
To be appointed,
Right. It's just you are making decisions now to avoid a judge making decisions for you later, and they may not be the same decisions you would make.
Okay. Mm-hmm. So I think if anything is clear from this discussion, the big planning takeaway here would be that, if it's a topic that has come up in conversation in your household,
right,
bring it back up, new year, right?
Right.
Let's address it and kind of check the box and move on. Shouldn't be as painful as it might seem to be.
It really shouldn't be. And it's one of those things you will feel so much better when you have a plan in place. It is an uncomfortable meeting with a lawyer to talk about all of your stuff. You will feel so much better when it's done.
Yeah. Okay. So the two questions that everybody else has been asked,
Okay.
which I know you've listened to all of these episodes, right? So first one, if you could buy anything in the world, regardless of what it costs, what would it be?
If I could buy anything in the world, it would be probably, honestly, a vacation home where I could take all of my family and extended family, somewhere that I could spend time with my people, the people I love.
Where would you want it to be?
Oh, gosh, somewhere warm and tropical.
There you go.
Now, I need more time to plan that place, but warm and tropical.
All right. Second question, the last two things you spent money on.
The last two things I spent money on were probably gas and beanbag chairs for my children.
There you go.
For the players.
All right. Okay. So hopefully you've gotten something out of this. And it's a kind of a heavy topic, but it's something we thought we should cover given the amount of interest that we've seen from our listening audience, I guess you would say. If you have questions or if you want to suggest topics for us to cover in the next few episodes, please reach out to us. You can find us on our website. It's at fostervictorwa.com. You can also follow us on Instagram at Foster Victor Wealth Advisors. Share this with a friend who you think might find it appropriate. Thanks for spending time with us. We'll see you next time.
It wasn't terribly scary.
Thank you.
Thank you. Appreciate it.
Information contained in this podcast was intended for general use, not to be used as specific advice. For content tailored to your personal situation, please contact one of our wealth coaches.